Hi, I'm Jeff Sivens, Chair of the EarthxLaw Advisory Council. I'm excited to present today this fifth in our series of Law and Nature on U.S. Supreme Court review of environmental cases. Our speakers include John Cruden, Principal at Beveridge and Diamond, former Deputy Attorney General of the United States for Environmental Issues, Bob Percival, Robert F. Stanton, Professor of Law at the University of Maryland and Director of the Environmental Law Program, and Sanne Knudsen, who is Professor of Law at the University of Washington, Stimson Bullitt Endowed Professor of Environmental Law. Take it away, John.
Jeff, thank you for that kind introduction. My thanks to EarthX and to Trammell Crow and to Bruce Fogarty for hosting us to what I assure you will be a really fun and informative presentation. We're dealing with the third branch of government. In our papers and all of our news accounts over the last month, you've all been watching the executive branch and you've been watching what Congress is doing, and we're going to turn to the Supreme Court. This is a particularly important term, and we're going to talk to you about things that are occurring right now in the Supreme Court, cases that are being argued. We have a new Supreme Court justice. We still have a coronavirus era. All of those things are happening at the same time that extremely important cases are being heard. Some of the cases heard before the administration changed and some of the cases afterwards, but these are the cases that will affect the United States law all during our lifetime. What we're going to do is we're going to open with all of us, each of us, talking a little bit about the Supreme Court generally, what's happening, how many cases, the impact of a new Supreme Court justice. That's happened this term, a new Supreme Court justice. We'll talk about how the court's handling that pandemic. And then we're going to turn to the Supreme Court cases. There have already been 3 that have been argued this term already. The term started last October. We're kind of midway through. And one of them has already been decided. So we'll talk about those 3 cases that have already been argued. There's several more that are set for argument. One will be argued on January the 19th. And then we're going to talk about some new cases that have just happened. 2 cases have just been accepted for the Supreme Court. We'll talk about those. And then finally, we're going to use our crystal ball a bit. And we'll talk about a few cases that haven't been yet accepted by the Supreme Court, but we think they might. And so, again, if you listen to one case and you're not as interested, stay tuned with us because I think you'll find other cases that you are going to be interested in. All right, so let's talk in general terms about this particular Supreme Court term. So far, the court has granted 61 cases. Of those 61, 28, not quite half have been argued, and 6 have been decided. And let me contrast that with last year. Last year, there were 57 opinions. That was the lowest number of opinions since the Civil War. And of course, that was because the pandemic took over, and for a while, and that hasn't happened since the early 1900s when the Spanish flu epidemic occurred, where the Supreme Court actually shut down. Last term, if you remember, we still had 9 justices, of course, but different. Ruth Bader Ginsburg was on the court. She passed away, a great justice that we all miss, but that changes the dynamic of the court. Last year, without question, Justice Roberts was the centerpiece of those decisions. In 97% of the cases, he was in the majority, which is extraordinary. It's sort of hard to imagine that happening this particular term because, of course, it's a completely different Supreme Court just by one different member. As a matter of fact, I'll pass this to you, Bob Percival, but I remember you telling me at one stage when you were clerking for your justice that he said that every new member of the court creates a completely different Supreme Court. But what kind of things have happened during the coronavirus era?
Well, for the first time since 1918, the court had to actually postpone oral arguments when the pandemic hit in March and April. And they ended up postponing some of those arguments until hearing cases in May, which they normally don't hear arguments in May, moved some of them to October. And the public has not been allowed to come to the court. They've been conducting the oral arguments telephonically, and that's had a major impact. Among other things, the way in which they're handling questions from the justices now are doing it in reverse order of seniority. So Chief Justice Roberts asked the first question, followed by Justice Clarence Thomas. And Clarence Thomas used to not ask questions at all. He went for 6 years without saying a word at oral argument at one point. And now he's fully participating in the arguments and asking some really good questions. It's sort of changed the interplay between the justices at the oral arguments. It used to be Justice Scalia used to like to debate the other justices. And if he didn't like an answer he got from counsel, he would say, well, what I thought you should have said was this. That doesn't happen anymore because they go through all the justices and that eats up almost all the time. And they really have to race through the arguments, given that they're guaranteeing that each justice gets to ask some questions at the oral arguments.
I read somewhere that you could hear the toilet flushing in one of the arguments. Did that really happen?
Yes, in April, one of the justices had not muted himself, and there was the sound of a toilet flushing. The court said nothing about it at the time, but of course, enterprising reporters caught that because these arguments are now being broadcast on C-SPAN, either on C-SPAN TV or over the internet. And then that started a big campaign to figure out what justice it was. And the betting is that it was Justice Breyer, who was going to be the next one to ask a question, who therefore had unmuted himself early. So Sanne is now going to talk about the new justice who was confirmed in almost record time in just 30 days, Justice Amy Coney Barrett.
That's right, Bob. And John mentioned that every new justice on the Supreme Court creates a new court. Well, there certainly has been significant turnover and change on the US Supreme Court over the past 4 years, and perhaps none more polarizing and mired in political controversy than the appointment of Justice Amy Barrett to replace the iconic Justice Ruth Bader Ginsburg. So as we think ahead with what the arrival of Justice Barrett might mean for the Supreme Court, and in particular what we think what that might mean in terms of the court's environmental jurisprudence, we would ordinarily be looking to Justice Barrett's record of decisions over time spent as a lower court judge, or we might look to some of her publications before joining the bench. But noteworthy here, the task of reading the tea leaves and making predictions through her record is a little bit more difficult because Justice Barrett is fairly young in her judicial career. She was appointed in record time, as Bob mentioned, in October of 2020 here by President Trump, but it was October of 2017 that she was first appointed to the judiciary at all with an appointment to the Seventh Circuit Court of Appeals. So just 3 years of a record before us. That's a remarkably short path to the US Supreme Court, and not many environmental cases in her history for us to dissect. There was a unanimous decision on the Seventh Circuit in a wetlands case where the court found that the Army Corps hadn't provided sufficient evidence to show that it had jurisdiction to regulate, but that's not much to go on. So given the limited data that we're working from, perhaps the best predictor of Justice Barrett's future on the court may be the fact that she holds herself out as a protege of the late Justice Antonin Scalia. And so we would expect, as he was and as she holds herself out to be, that she'll be a bit of a textualist and an originalist on the court. That doesn't necessarily tell us or answer the question of what that portends for environmental jurisprudence. Many of our major environmental statutes have strong textual support for aggressive congressional goals when it comes to environmental protection. But still, Justice Scalia was not seen as a champion of those textual aspirations. And so it still leaves open the question in my mind as to whether Justice Barrett, or where she's gonna come out on some of these cases. I think much more of a predictor will be her views on federalism and separation of powers between the branches of government. Lastly, I'll just say that if she follows suit and behaves like Justice Scalia, I expect that she will bristle at broad delegations of power to federal agencies like the EPA, but we'll have to stay tuned on the development there. I think at this point, we should dive right in and start talking about the cases that were decided. So I'm going to hand it back over to Bob to talk about Texas versus New Mexico.
This is the one case that the Supreme Court heard this term that it's already decided. It's an interstate water dispute. And as climate change becomes more visible and water is in scarcer supply, there have been more and more of these disputes. In fact, there are two other cases we'll talk about involving water disputes later in this program. One thing that happened at Justice Barrett's confirmation hearings that disappointed environmentalists was she was asked whether she thought that climate change was a serious problem, and she refused to say. Many people had hoped, especially since she's a fervent Catholic, like Justice Kavanaugh, that she would do what he did at his confirmation hearings and say, yes, it is a serious problem, and even make reference to Pope Francis's encyclical Laudato Si, that's an urgent call for the nations of the world to respond to climate change. Well, this first case, Texas versus New Mexico, was argued when the court held its first session this year on Monday, October 5th, and it involved a dispute over water from the Pecos River that flows from eastern New Mexico into western Texas. And what's odd about this is that normally in that part of the country, water is in very short supply, but this case dealt with what do you do when there's a sudden burst of rain. In this case, it was from the hurricane tropical storm Odile, dumped so much rain that there was no way that the Pecos River could hold it all. So it was stored in the federally owned Brantley Reservoir in New Mexico. Texas said, don't send us any more water. We're overwhelmed, we can't keep it. And the question was, because there were evaporative losses between the time the rain happened and when it was finally released and made available to Texas, would those be credited against the portion of water that New Mexico is required to allow to flow into Texas each year under the Pecos River Compact? This is one of only two cases where the court has appointed a river master in order to carry out the agreement in the compact each year to calculate exactly how much water is owed by each state. And here the river master, with a delay of a few years, ended up giving full credit to New Mexico for the water that was lost due to evaporation while it was being stored at the behest of Texas. And in many of these cases, they're heard within the Supreme Court's original jurisdiction to hear disputes between states. And the water controversies are usually the classic example of these original jurisdiction water cases. Usually the court ends up deferring to the master. In most of these cases, there's what's called a special master. Here it was just a river master who's not supposed to act like a judge, hearing evidence and deciding, making recommendations about how to decide a case, but to be more of a ministerial function of just calculating how to apply the formulas that have been agreed to. And Texas alleged that the river master had exceeded his authority in this case, but nonetheless, the court by a vote of 7-1 with Justice Barrett not participating because she hadn't been confirmed yet when the case was argued on October 5th, ruled in favor of New Mexico and said that the river master had been right, that his calculations were legally accurate and entirely fair. The only justice who dissented in what was called kind of a prickly dissent was Justice Alito. And it turns out, I discovered afterwards, that the Texas Solicitor General, who had argued the case for Texas, had been a former law clerk to Justice Alito. And he said that that the case should go back and the river master should have to do it over again. But by 7-1, he was outvoted. And so New Mexico won the first of the interstate water disputes that was decided this year. Now, there have been 2 other cases that have been argued where we're awaiting a decision from the court. And the first of these is a Freedom of Information Act case involving the Endangered Species Act that Sanne is going to tell us about now.
Yeah, thanks, Bob. That's the United States Fish and Wildlife Service versus Sierra Club case. And it involves the scope of what's called the deliberative process privilege under the Freedom of Information Act, or FOIA, which is an act that gives ordinary members of the public and organizations like Sierra Club the ability to request federal government records. Not surprisingly, there are a number of exemptions to FOIA requests, and one of those exemptions allows the government to withhold records that were part of the deliberative process. Getting the scope of the deliberative process privilege right is a difficult balancing act between valuing transparency and accountability on the one hand and fostering candid federal agency deliberation on the other. As Bob mentioned here, the dispute over the FOIA's deliberative process exemption arose in the context of the EPA, the Environmental Protection Agency's adoption of a rule pertaining to cooling water intake structures under the Clean Water Act. And as part of that rulemaking process, the EPA was required to consult under the Endangered Species Act with the Fish and Wildlife Service and the National Marine Fisheries Service to make sure that the regulation for cooling water intake structures wouldn't jeopardize the continued existence of an endangered species or otherwise adversely modify critical habitat. By way of brief background, cooling intake structures are used by industrial facilities such as power plants to draw large volumes of water from the ocean or from other water bodies into their cooling systems. And these intakes can harm aquatic life by trapping fish and other large organisms in the intake screens, and also by sucking in smaller fish larvae, eggs, and other organisms into the intake. And so the EPA was required to consult. When they consulted, the Fish and Wildlife Service and the National Marine Fisheries Service initially found that the EPA's proposed rule would jeopardize species protected under the ESA. And so they drafted a set of 2013 biological opinions reflecting this conclusion, and they sent that over to the EPA. The EPA revised its rule based on these biological opinions and sent the revised rule back over to the services for further consultation. And at that point, the services concluded that the new rule would not jeopardize listed species. So in the meantime, in a FOIA request, Sierra Club had asked for copies of that December 2013 biological opinion and other related documents. And the services invoked the deliberative process exemption to withhold those documents. And the case eventually then has made it now to the Supreme Court to help determine the scope of that exemption. Now, this is a case where the court heard argument on November 2nd, 2020, and this was the first case argued before the court since Justice Barrett took the bench. Sierra Club argued that the exemption didn't apply, obviously, explaining that any decision made by an agency that has appreciable legal consequences should not be, the documents should not be withheld under FOIA. Justice Barrett expressed concerns about the fact-intensive nature of applying that kind of standard, the standard of appreciable legal consequences. She and other justices like Justice Gorsuch and Kavanaugh seem concerned about laying down a bright line rule for clarity on whether the exemption applied. Chief Justice Roberts asked a series of questions suggesting that perhaps the 2013 biological opinion would be pre-decisional and therefore able to be withheld. But Justices Alito, Breyer, and Kagan suggested, on the other hand, that perhaps those documents could be considered final documents. So as I noted earlier, this is a thorny issue of balancing transparency with robust agency deliberation. And perhaps of note, there were 6 amicus briefs filed in this case in support of Sierra Club, emphasizing that the services frequently release these kinds of documents in recognition of the important public interest that is at stake by allowing industry and conservation advocates with a deeper understanding of the Section 7 consultation process. So this is going to be, it's going to be difficult, I predict, for the justices to draw lines in this case. And we'll have to see where they come out on this. Hopefully, we will see a brighter line rule so as to cut down on future litigation on this point. But that wasn't the only case that was argued and that we're going to talk about today. We've got John. He's going to talk to us about the Nestle versus Doe case, which is another case that has been argued in this term. So I'll turn it over to you, John.
Thank you. This case, Nestle and Cargill versus Doe, really tugs at your heartstring. These are 6, they're adults now, but they were kids when all the things happened to them. And, they're from Mali, but they were forced to work, probably kidnapped to work in the neighboring, country of the Ivory Coast. And they presented a complaint saying they were forced to work 12 to 14 hours a day and they were beaten if they didn't do enough work. And so they brought this case and it's really challenging what the companies did, even though the companies clearly were not kidnapping them, but they're arguing that just by buying the cocoa beans and having this part of their supply route, that they could be charged with abetting those people who were clearly involved in reprehensible conduct. And so the argument, though, is under something called the Alien Tort Statute. This is an old statute from the 1700s, but really gives the ability in some cases for foreigners to bring cases into United States courts. The Supreme Court, in a couple of decisions over the last 4 or 5 years, have narrowed the application of the Alien Tort Statute, but it's still a viable statute. So coming before in the arguments before the Supreme Court were a couple of cases. First of all, can these 6 individuals, which we call John Doe because they doesn't actually name their name, so we say they are John Doe, can they actually sue a corporation? And if they can they sue a corporations for things that happen exclusively in a foreign country, here in the Ivory Coast? So both of those are before them. But so they're really reprehensible facts. However, tying them to the corporation is very difficult. And that's the way the oral argument played out. The oral argument played out, would we have do we want a rule of law that said you can never sue corporations? You could sue individuals, of course, but could you never sue corporations? Do we have a rule of law about how much evidence do you have to have and how applicable is it that it's only in a foreign country? So it's very difficult to determine how this case will be decided. The only thing I will say is historically, and certainly in the last 2 or 3 years, the Supreme Court reverses about 70% of the cases they take. So if you're making a guess, you would guess, well, they'll reverse it. But this is a case out of the Ninth Circuit, which sits predominantly in San Francisco, and they tend to reverse most of the Ninth Circuit cases that they get. So my guess would be that they would reverse it, but it might be on very narrow grounds, not the broad grounds that Nestle and Cargill are presenting. Okay, but those are the cases that have already been argued. Now we want to turn and talk to cases that are going to be argued. Supreme Court has taken them, but they have yet to be argued, at least as argued as of today. And the first one would be our only really climate case involving BP versus Baltimore. Bob, you want to take that?
Sure. It is nominally a climate case, but the actual issue before the Supreme Court is a very technical issue concerning the reviewability of remand orders by federal district courts denying removal of state cases to federal court. What happened was a while ago, the city of Baltimore sued 21 domestic and foreign oil companies, arguing that they had, under Maryland state law, committed a tort by promoting their products while in the state of Maryland, while knowing that climate change was going to be exacerbated by the use of them, and while deceiving the public about climate change not being a serious problem. These cases are part of a whole bunch of cases where cities or states have sued the fossil fuel industry in state court. The state of Rhode Island's brought one of these suits in Rhode Island court. The county of Boulder, Colorado, several cities and counties in California have sued. And in every single case, the oil companies have tried to remove the case to federal court. And they've alleged that these are really cases that should be governed by federal law and not state law, even though on their face, the only thing they're being accused of doing is violating state law through a fairly garden variety tort. And when the cases got to the federal district court in Maryland, that court decided that they actually were truly state law cases and belonged in the Circuit Court of Baltimore City. And so they remanded the case back, and that was then appealed to the Fourth Circuit. And the Fourth Circuit said that there are only two circumstances in which district court remands of cases that were tried to be removed from state to federal court can be reviewed by the U.S. Court of Appeals. That's under 28 U.S.C. section 1447D. The only two grounds on which an appellate court can review remands of removal orders are in civil rights cases. This is not a civil rights cases. And in cases removed on grounds of federal officer jurisdiction. And the oil companies are making this fairly far-fetched argument that because the federal government and the Defense Department bought oil from the various companies, that they were required to produce oil, and that's why they're being sued. I call that the feds made me do it argument. Of course, that didn't fly in the Fourth Circuit, and then the Fourth Circuit said, therefore, that's the only basis we can review this. We're sending it back to the district court and to be remanded back to the state court. But the oil companies are arguing that there was one decision, even though there was almost unanimous agreement about how to interpret the federal removal grounds, there was one case from the Seventh Circuit where Judge Frank Easterbrook of the Seventh Circuit wrote an opinion in an airline accident case saying that as long as the circuit court is hearing the grounds for removal, they should be able to hear any other grounds that's asserted. And what the companies are doing, and I think this is a way of trying to appeal to what they know is a very strong conservative majority on the Supreme Court that won't like climate cases, is they're actually arguing that these cases should exclusively be governed by federal common law. Well, that's not the way the pleadings are in the state courts. They were only asserting state common law, but they're doing that because in 2011, the Supreme Court in the American Electric Power case, involving a case where several states sued utilities with coal-fired power plants and asked the federal judge to order reductions in greenhouse gas emissions, the Supreme Court unanimously ruled that the Federal Clean Air Act displaced the federal common law because EPA had authority to regulate greenhouse gases under the Clean Air Act, as established by the Supreme Court in 2007 in the Massachusetts versus EPA decision. Now, in their brief before the court, and this is actually going to be the last case argued before the Supreme Court before President Biden is inaugurated, the Solicitor General doesn't come right out and say, well, you should basically hold that all climate litigation arises under the federal common law, but he does say there may well be a valid alternative basis for federal jurisdiction based upon the fact that the companies argued that these really are governed exclusively by federal common law and not state law. Now, I suspect that the Biden administration is not going to adopt that position, but that's the position that the Solicitor General has briefed and argued and will be arguing before the Supreme Court. So I sort of see that as kind of an invitation to the conservatives to reach out and decide an issue that shouldn't really be before them. If they're deciding this narrow question of how do you interpret the federal removal statutes, a civil procedure and appellate jurisdiction issue, you wouldn't expect any specific ideological split in the court on that issue. And so we'll see what they do, but it's pretty clear what the oil companies would like them to do. But as the city of Baltimore says, that was not argued below. That's not before the justices. It wasn't in the questions presented. So we'll have to look and see what they do with that. Now, another case that's scheduled for argument on February 22nd is another one of these interstate water disputes, Florida versus Georgia. And what's interesting about this case is that even though it's from the eastern US, where the water cases used to be very different because it was about having a lot more water than the drought conditions out west, here, as Atlanta has grown so rapidly and Georgia's consumption of water has increased a lot, the state of Florida has been arguing that the flow of water through the Apalachicola River has been drying up and they're not getting enough, and it's hurting the oysters that Florida would otherwise raise. The litigation's been going on for quite some time, and there was a special master who was originally appointed, and in 2018, the special master had dismissed the case, saying there was no way that any relief could be given to Florida because they didn't really control the flow of water. The argument was that they consume way too much water, so there's less water flowing through dams that the Army Corps of Engineers operates. And he said, therefore, Florida has no standing because I can't provide any redressability. And in a very unusual decision, the Supreme Court, by a vote of 5-4, you rarely see sharp 5-4 splits in these interstate water cases, actually reversed the special master's findings and ruled in favor of Florida and said that Florida has a lot of equities on its side because it's quite clear that they're being greatly affected by the reduced flow of water from Georgia. And this was a case where an oral argument, Justice Breyer had said, can't there be some way that you can find to give Florida more water? We could actually try this case before ourselves if we wanted to. But the difficulty now is They then replaced the special master, got a new special master, and he essentially has concluded the same thing, that there's no practicable way to give relief to Florida in the case. And in predicting how this might come out, one thing that's greatly to Florida's disadvantage is that 2 of the 5 justices that had been in the majority when the case was decided in June 2018, Justice Ruth Bader Ginsburg, who's died, and Justice Kennedy, who's retired, no longer on the court. So in the meantime, all of the justices, Justices Gorsuch, Kagan, Alito, and Thomas, who were in the dissent 2 years ago, are still on the court. So it's pretty much going to be decided by how Justice Kavanaugh or Barrett feel about this, or it may be that some of the people in the majority will also agree to uphold the special master's ruling. Now, this case will be argued after the Biden administration has taken over. And the question is, would they be more sympathetic to Florida? If you were going to look just on standard political social choice theory, what state is more important to the Biden administration right now, the state of Georgia or the state of Florida? I wouldn't put a lot of faith in the notion that Florida is going to be able to win this one, even though they certainly are hurting for water right now. So there are 2 other cases that are scheduled for oral argument, or not, that are going to be argued this year. One's already scheduled for oral argument that same day on February 22nd. And John's going to tell you about them now.
Thank you. You were pointing out that some of these cases that we're talking about are really going to be argued by the Solicitor General's office of the Trump administration, and all the pleadings were by the Trump administration. But now you and I are talking about new cases in February. That'll be a new Solicitor General. There will be a new Solicitor General arguing before the Supreme Court. We don't know who that is right now, and so there could be new positions. And there's no better example of that than the border wall case. Everyone, all of you remember what a hue and cry there was in the press, and a campaign promise by President Trump. He wanted a border wall, and he wanted a wall that Mexico would pay for. And of course, Mexico did not pay for it. And that resulted in 2018 and 2019 to a shutdown of the government. They could not agree on appropriations. And when they finally did, the Trump administration still did not have all of the money it needed to do the border wall. And so the president declared a national emergency, which gave him some authority to reprogram something in the magnitude of $2.5 billion that came out of the Department of Defense's Appropriation Act, and then use that for the border wall. That's the case. That's the case that has been challenged now in the Ninth Circuit, through the district court in the Ninth Circuit, challenging whether or not President Trump could really do that. Could he really use Department of Defense money appropriated for the Department of Defense? Could he reprogram that and use it for the wall, which he is currently doing? That is currently happening. On several occasions now, they've gone to the Supreme Court, and the Supreme Court stayed an injunction. There was an injunction at the district court level that said you can't do that anymore. Supreme Court disagreed. Then the Ninth Circuit on the merits ruled that President Trump was wrong. They have again went to the Supreme Court and said, would you would you lift your injunction so you can't have anything more done on the wall? Supreme Court disagreed. And so the case that's before the Supreme Court, going to be argued during the Biden administration, is whether or not that was proper, whether or not the assistant or secretary or the assistant secretary who made that decision under the Appropriations Act, whether or not they could really do that. And even if they could, is there basically standing by the Sierra Club and the environmental groups to challenge that. I can only imagine that during there might be a completely different position by the Biden administration about the wall. But if there is, they're going to have to work very quickly after they come into power to affect an argument that's already been briefed, already been set to go forward on February 22nd. I think while I'm doing this, I want to turn to a case that you probably haven't heard anything about because the Supreme Court just took a cert on the case. It just happened. And so I'm going to tell you just briefly about a case where Guam has sued the United States. So the country of Guam has sued the United States and they want money. This is a somewhat famous landfill called the Ordot landfill in Guam. It's been in effect for 60 years. It's been a horrendous problem in Guam. There was just illegal dumping and the Department of Justice some years ago sued them under the Clean Water Act for violating the Clean Water Act because the discharge was actually adversely impacting waters of the United States. They had a consent decree in something like 2004 prohibiting that action, requiring cleanup. And then Guam didn't do anything, didn't do what they were supposed to do. So one of the first times I can remember in history, they put Guam in a receivership. They put a receivership in 2008 to make sure that Guam did all the things they were supposed to do to protect the health of the Guam people. Now, fast forward until 2017, and Guam sues they sue the United States, but it's really the Navy saying, we want money. We want money for the cleanup. The district court agrees. This case can go forward. It go forward under the Superfund laws. It went to the DC Circuit, and DC Circuit said, no, you can't. You cannot go forward. And the reason why you can't is because of that Clean Water Act consent decree 13 years ago. So 13 years ago, that's what triggered your right to what we call contribution. Contribution means you're sharing the pain. You have pain because clearly Guam is going to have to spend some money, but you want to share that pain and have other people contribute to it. And that's under a section called 113H of the Superfund or CERCLA law. So the DC Circuit said no to that. But that's the case the Supreme Court just took cert to determine whether or not the country of Guam is barred because of an old consent decree under a different statute or not. It's just happened. Interesting case that's happened. There's another case though that called Holly Frontier that the Supreme Court just recently took. Bob, what's that case about?
Most people didn't expect the court to take it, so it was kind of a surprise on Friday when they announced that it was. It involves a pretty narrow question of interpreting a portion of the Clean Air Act. When Congress added the renewable fuel standard that requires oil companies to blend in an increasingly share of biofuels, renewable fuels, when they make gasoline, they realized that it might be harder for small refiners to comply with that. So they added this section to 211.0, the renewable fuel standard, that allows EPA to grant a temporary extension of exemptions to small refineries if they can show that they're having economic hardship. And the Department of Energy had to do a study that said, yes, some small refiners will have economic hardship. So EPA can exempt them from this renewable fuel standard requirement. The section actually says, as its title, temporary extension, which allows them, if they can show that they're still having hardship, to get a 2-year, at least a 2-year extension of that exemption. Now, the 10th Circuit said, because the word it uses, the statutory language says, extend the exemption, any refiner who previously no longer had the economic hardship and therefore didn't have the exemption can't get it back. You have to be extending an exemption that already is in existence. And so it's an issue of statutory interpretation. Holly Frontier is saying the word extend in the dictionary can mean to make available. It can also mean to increase the length of something you already have. We think it should be interpreted to make available. So if we have economic hardship in 1 year, but not another, we should be able to get the exemption back. There's a similar case before the DC Circuit. There's no obvious circuit conflict yet because this is the first time this issue has been raised. The Solicitor General said until there's a circuit conflict, there's no way the court should take this case, but it took it anyway. Solicitor General also said, even if they win the case, it's not clear that they can still establish that they're entitled to an economic hardship exemption. And I would imagine in the Biden administration, they'd be loath to grant very many of those because they'd want to encourage the use of biofuels. So we'll find out how they interpret the statutory language. We may get a nice debate by the court on theories of statutory interpretation and what the real dictionary meaning was in the word extend in this portion of the Clean Air Act.
Yeah, so we just heard about some cases where the court has very recently granted cert, and we are keeping our eye on a number of cases that would be of interest, and one of them is Montana versus Washington. So while we normally think of the US Supreme Court as hearing cases appealed from the lower courts, this is a case where Montana and Wyoming filed a complaint asking the court to exercise its original jurisdiction in a coal export terminal dispute with the state of Washington. That is, this case originates in the US Supreme Court because it's a dispute between states. In particular, Montana and Wyoming assert that Washington violated the Dormant Commerce Clause and the Foreign Commerce Clause when it used its authority that's given to states under the Clean Water Act to block a coal export terminal project along the Columbia River. That terminal was intended to export 16 train loads of coal per day from Wyoming's Powder River Basin to markets in Asia. Now, as framed by Montana and Wyoming, the case raises interesting issues of whether coastal states can block landlocked states from accessing ports based on the coastal state's own environmental objectives, like curbing downstream carbon emissions. The state of Washington filed a motion in opposition, claiming that the court would simply be wasting its time if it were to exercise jurisdiction, because the coal export terminal project was not really a conflict among the states. Washington emphasizes that this is a private project proposed by a private company on private land. What's more, Washington argues that the project is dead in the water, even if it did receive the state of Washington's 401 certification. Washington explains that the 401 certification was just one of several regulatory hurdles that the company had failed to clear. And because of that, Washington argues that these claims that are brought by Montana and Wyoming are not redressable by the court, that the court couldn't cure the harm being alleged here, and that therefore the parties lack standing, and that therefore the court has no power to decide this case. Now, importantly, the Washington Department of Ecology denied the required 401 certification under the Clean Water Act with prejudice, meaning that the company seeking the permit or seeking the certification could not later seek approval, even upon presenting different or additional evidence. So Montana and Wyoming argue that that leaves the door open and that the court still can provide redress by undoing the denial with prejudice, because then at least the company could pursue this project again in the future. Notably, none of the other projects or none of the other permits involved in this dispute were denied with prejudice. So the court has yet to make a decision as to whether to take this case. The Solicitor General was invited in early October to file a brief expressing the government's views. Nothing's been filed so far, and in any event, those views may change with the change of presidential administration, but that would be an interesting case if it were taken. There's another case. There's a lot of cases actually that are interesting in the on deck circle. The next case I want to talk about is Massachusetts Lobstermen's Association versus Ross. This is a case that challenges President Obama's use of the Antiquities Act in September of 2016 to establish a 3.2 million acre Northeast Canyons and Seamont Marine National Monument more than 100 miles off the Atlantic coast. Now, the Antiquities Act of 1906 confers discretion on the president to declare objects of historic and scientific interest as national monuments on land owned or controlled by the federal government. And under the act, those parcels that are designated as national monuments are supposed to be confined to the smallest area compatible with the proper care and management of the objects that are to be protected. So here, the petitioner, Lobstermen Association, argues that the President Obama, did not have authority to protect areas beyond the territorial seas of the US, and that the size of the monument exceeded the smallest area compatible with what was necessary. So on the issue of presidential authority, the Lobstermen Association argues that the monument not only exceeds the president's power under the Antiquities Act, but that it circumvents another congressional statute called the National Marine Sanctuary Act, which requires a specific process for designating marine sanctuaries subject to review by Congress and affected states. So this is interesting because on June 17th, 2020, President Trump signed a proclamation lifting fishing restrictions in the monument, which is not part of this lawsuit. That's a decision that environmental groups are challenging in a separate lawsuit. But that proclamation does not actually moot the question of whether the president has authority to designate monuments in this area at all. In fact, the fact that President Trump lifted restrictions would suggest that President Trump also believes to have authority to act in this space. So here we have the Solicitor General filing on behalf of the Secretary of Commerce, Ross, filed a brief on December 4th opposing the grant of cert in this case. And there the solicitor is arguing that the United States does have jurisdiction in these waters in what's called the exclusive economic zone, and that jurisdiction of the United States is firmly established. It was an area that President Reagan established this area in 1983 by proclamation. And since then, Congress has enacted a number of statutes that regulate economic activity in and the conservation of marine environments in the exclusive economic zone. So the solicitor is relying on congressional statutes as evidence of US jurisdiction here, and arguing that therefore the president has authority under the Antiquities Act to designate monuments in this area as well. The solicitor also points out that previous presidents, so President George W. Bush, have also established monuments in marine areas that fall within the exclusive economic zone. So President Bush established the Northern Hawaiian Islands Marine National Monument in 2006. The Natural Resources Defense Council filed a similar opposition brief, and this case was distributed for conference on January 8th. So that's one case that we're keeping our eye on. And the last case that I'm going to talk about anyway on the on deck circle is a case called United States versus Utah and Kane County. This is a case in which Kane County and Utah sued the federal government to claim title to rights of way on 15 roads that were crossing federal public land in Utah. two environmental groups, the Southern Utah Wilderness Alliance, or SUA, and the Wilderness Society, sought to intervene in that litigation because of their interest in preventing possible harm to surrounding area from increased traffic if the state of Utah and Kane County were to be held to have title to those rights of way. Now, in 2009 and 2011, just to give a sense of how long these pieces of litigation go on, 2009, 2011, SUA was denied intervention in this litigation on the grounds that their interest was adequately represented by the federal government. But then SUA moved again for intervention in 2018, a new presidential administration, arguing that the litigation position of the US had changed and that they should therefore be allowed to intervene. The district court denied SUA the right to intervene, and then a divided panel of the 10th Circuit reversed. It held that SUA was actually entitled to intervene because its environmental concerns would not adequately be represented by the US in defending its title over the land. And so this is an interesting case that at its heart involves a dispute of rights of way over public land, but the Supreme Court is being asked to weigh in on an issue of federal civil procedure and whether or not under Rule 24 of the Federal Rules of Civil Procedure, these environmental groups have a demonstrated right to intervene in the case. Perhaps of interest, this case is part of a larger landscape of similar quiet title actions that have been filed since the early 2000s by the state of Utah. In fact, since the early 2000s, the state of Utah legislature has passed a number of statutes authorizing and funding these particular kinds of quiet title cases, and the legislature has expressly declared it to be the policy of the state to claim and preserve by lawful means the rights to determine and affect the disposition and use of federal lands within the state. So this is interesting. SUA is a significant and longtime wilderness watch group in Utah, and it's a repeat player in opposing these actions. This is a case where this case has actually been distributed for conference on December 4th, and then again on the 11th, and then again on January 8th. So it seems to be one that the court can't quite decide whether it wants to tackle this issue. Interestingly, Justice Gorsuch came to the Supreme Court via the 10th Circuit, so he would surely know a thing or two about these rights of way cases. None of the other justices hail from the Western lands, and so they're maybe less familiar with the with these particular cases, though surely they're quite familiar with the federal rules of civil procedure. So we've got a couple more cases on the on-deck circle that we are tracking, but I will pass the baton back to John to talk about those.
Thank you. I mentioned in the border wall case that the Supreme Court intervened and stayed the injunction. We've seen more of that than ever before in the Supreme Court recently. Bob, I know you've been looking at that in the context of a more significant climate case that's still pending in the Ninth Circuit. What I think of as the children's case, Juliana. What did the Supreme Court do in that case?
They actually ended up staying the trial that was about to start taking place in a case where several children, at least they were children at the time the suit was filed 5 years ago, sued the federal government, claiming that it had failed to protect them from the effects of climate change, and that violated the federal government's substantive due process obligation to do so. The Supreme Court stopped the trial essentially, and then was able to get the Ninth Circuit to step in and get the district judge to grant interlocutory review. And then a panel of the Ninth Circuit about almost a year ago ruled that the plaintiffs did not have standing to sue the federal government over climate change because the courts were not capable of providing redress in coming up with a plan to reduce greenhouse gas emissions, that was a job for Congress and not the court. That's now on a petition for a rehearing en banc before the Ninth Circuit. And there's a big debate in the environmental community about would you, if you lost that petition for rehearing en banc, take it up to the Supreme Court where you know the 6-3 conservative majority is likely to quash it.
Yeah, I should actually mention just quickly on the Penny's case, and then we'll close with Sanne talking about the Keystone Pipeline case. People don't know this, but the eminent domain authority, which we think of as being used exclusively by the federal government, that's not really true. FERC, when it authorizes, can actually delegate that authority, and they did so in this case. This is a case where you have a natural gas pipeline over 100 miles going from Pennsylvania to New Jersey. It was authorized, but part of it was going through land that New Jersey state had an interest in. So now you are abutting the statute versus the constitutional sovereign authority of the state, and they have abutted up against each other. And so now the court ruled on this, Court of Appeals, saying, notwithstanding the fact that you could have a lawful delegation to a non-federal government, this is Penny's having that delegation, notwithstanding that might be lawful, could be unlawful, constitutionally unlawful, if you're butting up against something that the state has a significant interest in. So they ruled against that case. Now is the justices have asked for the views of the Solicitor General, and the Solicitor General filed an amicus brief saying that the decision below is incorrect and should be reversed. The Supreme Court hasn't done anything with that, but that's another case that we have been looking at. We're going to close our discussion, though, with the Keystone Pipeline case, which has a lot of attention, but we're looking pretty narrowly at that same issue that Bob was talking us through. And it's another case like the border wall case where the Supreme Court jumped in before the case was decided and stayed part of it. So, Sanne, what happened in that case?
Yeah, so this is a case involving the construction of the Keystone Pipeline. As John mentioned, one of the regulatory hurdles to pipeline construction is securing permits under the Clean Water Act from the U.S. Army Corps of Engineers wherever the pipeline crosses streams or wetlands. And in meeting that regulatory requirement, the Keystone Pipeline project relied heavily on what's called the Nationwide Permit 12, which is a general permit issued by the Army Corps that saves developers from securing individual permits. The nationwide permits can then be used when certain activities in federal jurisdictional waters and wetlands have no more than minimal adverse environmental impacts. In litigation, however, in reliance on that nationwide permit, that reliance on the nationwide permit was challenged because of the alleged cumulative impacts from the Keystone Pipeline on endangered species as a result of the multiple stream crossings. So in May of 2020, a U.S. District Court for the District of Montana held that the Army Corps had violated Section 7 of the Endangered Species Act by allowing the use of the nationwide permit, but by failing to consult and consider the cumulative impacts on listed species. The district court vacated the use of Keystone Pipeline project, their reliance on nationwide permit 12, but all at the same time issued a nationwide injunction barring the Corps from using it to allow water crossings in other projects, other pipeline cases. And so what's interesting here is, as John and Bob mentioned, rather than this case proceeding through appeal up to the US Supreme Court through the regular lengthy process, the Supreme Court jumped in July of 2020 and stayed the vacature order, lifting the injunction, the nationwide injunction for all pipelines except for the Keystone XL pipeline. So the Keystone XL pipeline is still enjoined from using nationwide permit number 12, but the injunction as to other projects was lifted. On the regulatory front, the Army Corps has responded by in September proposing to reissue nationwide permit 12 and effectively split it into 3, one that would deal with oil and gas pipelines, another that would deal with electric lines and utilities, and a third that would deal with water, transportation of water and sewage. And that proposed nationwide permit 12 was actually finalized just this year on January 4th. So, but it's an interesting case, not just because the Keystone Pipeline is of interest, but also because of the pattern of the US Supreme Court jumping in some of these high profile cases.
So to our EarthX audience, that brings to a close our overview of the Supreme Court term as it exists right now. If you remember what we said at the outset, we talked about a Supreme Court term that bridges one administration now going into the Biden administration. It has a new justice. And as Bob has pointed out, we're in the middle of a pandemic and they're still dealing with that. We're still having remote arguments today. We gave you an overview of the one case that's been decided and the several cases that are to be argued, and then the newest cases that have not yet been set for argument, but the Supreme Court will take. And then we tried to give you a glimpse into all of, there's hundreds of cases pending right now. We tried to pick out 3 or 4 of the environmental cases that we thought the Supreme Court might be interested in. And then Bob and Sanne just ended with a current issue, and that is the Supreme Court taking more and more cases that they might issue a stay in, as they did in the Keystone Pipeline, the border wall, and the Juliana case, even before that decision was over. We want all of you keep following the Supreme Court, keep looking what they're doing. It's such an extraordinary and important institution in the life of environmental law in the United States. And with that, we bid you all the very best from the 3 of us.